we finished talking about the elements of a crime, those things that the prosecutor must prove beyond a reasonable doubt to establish the defendant's guilt of a crime. We're going to switch gears to the defendant now and speak about criminal defenses. There are defenses to crimes that may allow a defendant to be let go or acquitted, or allow him to argue something less than what he was charged with. So we talked about the prosecution's case. So when the people are done presenting their case to a jury, they rest. They'll say, Your Honor, the people rest, and they'll rest their case, and the defense has an opportunity to present evidence. But like I said, they don't have to. It's up to the people to prove the case beyond a reasonable doubt. But they certainly can present a case. And there are numerous types of defenses. And in my opinion, every case that goes to a trial, there has to be some sort of defense. Otherwise, there wouldn't be a trial. Somebody would agree to solve their case by a plea agreement. Even if the defendant doesn't even put on any evidence, if there's a trial, they're going to assert something. And some of those things, or all of things, will fall in kind of one of these. A flat-out denial. I didn't do it. Go ahead. People, prove your case against me. A failure of proof. They might say, they might attack one of the specific elements of a crime. We'll talk specifically about these. They might put on something that's called an affirmative defense. We'll talk about the difference between a perfect versus an imperfect defense, factual versus legal defense, and justification versus an excuse. And I like talking about the OJ case. If you're interested, it's one of the trials for the trial paper. If you pick OJ, there is actually a YouTube page of the entire trial from beginning to end, but I will warn you that the trial itself lasted well over a year, and there was lots of hearings and things that happened before it, but the trial itself, I think, was 366 days. But nonetheless, OJ's argument was he didn't do it. It must have been somebody else. And what you're seeing here is one of the key things that happened at trial was his attorney argued, if the glove doesn't fit, you must acquit. It was a great phrase that was used, and the prosecutors got OJ to try on the gloves. That was the defense's intent, and they didn't fit. Now, it was I'm not going to go into it, but it was a big prosecution error. And if you are looking into this case and doing this case, focus on the gloves and whether or not I'm telling you, there was a big faux pas regarding the gloves, and it's a good particular issue to focus on if you were going to do this case. But purposes of defense, denial. Glove doesn't fit, you must acquit. Someone else did it, and that was their argument right along. And if you're familiar with one of my all-time favorite trial movies, My Cousin Vinny, and if you haven't, you must see it because it's hysterical. And yeah, it's a little dated and old, but, Joe Pesci is quite funny. But the defense in this case, mistaken identity. Isn't it possible that two other guys in the same vehicle came into the store after these guys left? That was his argument, and that goes towards the failure of proof, because the district attorney has to prove that these defendants actually committed the crime. That's one of their elements that they must prove. So mistaken identity. He didn't put on any witnesses. He just attacked the prosecution's witnesses to give some doubt whether or not that the witnesses actually saw these two guys. So that was a good example of a failure of proof. The other things we're going to discuss, like I said, other defenses, justification, insanity, alibi. We're going to discuss, we had already discussed the constitutional defenses, right of privacy, right to bear arms, right of free speech. And when the defendant puts on their defense or uses some defense, one of two things will happen. Either there'll be a flat out acquittal. What does acquittal mean? The jury comes back with a not guilty verdict, and the defendant's free to walk out of the courtroom. Or a successful defense would be reducing the charge. If somebody's charged with murder in the first degree, the district attorney has to prove some level of purposefulness or premeditation. And if they don't, the charge can be reduced to maybe murder too. And that is a successful defense, especially if you're in a state that has the death penalty, because murder 1 carries a potential penalty of a death penalty, and murder 2 does not. So the other thing we're going to talk about is, depending on the defense asserted, will depend on who has the burden of proving it, because sometimes the prosecutor has to prove that there is no defense here available, and on other times the defendant actually has to prove their defense. So let's jump in and talk about affirmative defenses. So what is an affirmative defense? It's something that a defendant raises, and it is a defense that is actually set forth in the statutes, in the criminal code, some other statute, or it involves a matter of excuse or justification that's just within the knowledge of the defendant. But it's the defendant who has to put something forward, okay? So let's talk about this. Most of the defenses, actually all of the defenses we're going to talk about here going forward, are set forth in a statute. Things like failure of proof and the denial, those are set in motion by some knowledge of the defendant, right? Or the people didn't prove their case. The people can't prove their case when it's a denial. Failure of proof is they can't meet one of the elements. We just went over that. But when we talk about specific affirmative defenses that are coming up, they're going to be spelled out in a statute. So it's something the defendant raises. When do they raise it? Usually at their case. After the people rest, they will start presenting witnesses. However, it is very clear early on what their defense is going to be, and usually the prosecutor is going to know because there's been some sort of discussions. It's not like they don't talk to each other, the defense attorney and the prosecution. And the jury or the trier of fact, if it's, the judge too, will pick up on it based on how the defense attorney is questioning the people's witnesses. Also, in a trial, they get to make opening statements. They get to make statements, and sometimes the defense attorney will allude to their position in the opening statement, but it's up to the defendant to raise it, okay? It requires proof, and two things we got to discuss is by who and by what standard. Basically, it's the defendant that has to put that proof forward. And by what standard? They will never be held to a standard of reasonable doubt. So let's talk about, what do I got here? Let's go through this example. A fight breaks out at a party. Toni is severely injured. Mike and Rob are arrested. Rob asserts, "I didn't touch him, someone else did." So what does the prosecution have to prove here? This is like the OJ case, right? You can't prove that it was him who did it. Rob, you can't prove I touched it. Is there a defense? The defense is going to be a failure of proof because the prosecutor has to show that Rob was the one who did it. And if they do, then Rob could be found guilty. Let's look at this other example. Mike says in his criminal trial, "I was defending myself against Toni's attack." Is there a defense? Sure, Mike's defense is, "I was protecting myself." We might call that let's just call it self-defense. We're going to talk real specifically about self-defense, but what type of defense is it? It's an affirmative defense. This is going to be something that's going to be outlined in a statute, but this means this is something that Mike is going to have to prove. So the burden is on the defendant to prove his affirmative defenses. Okay? And this is going to depend from state to state, but most of them require the defendant to prove their affirmative defense. I'm going to give you an exception in a second. So does that mean beyond a reasonable doubt they have to prove that affirmative defense? No, they will never, the defendant will never have to prove something beyond a reasonable doubt. That is completely up to the government to have to prove a case against somebody. Their burden is very much like a civil case, the preponderance of the evidence, more likely than not. That's a smaller hurdle than the reasonable doubt standard. That's all they need to show, which means they have the burden of production. We've talked about this. This is producing evidence for their affirmative defense. And they have the burden of persuasion, which means they have to convince the trier of fact that in fact there was an affirmative defense here. So that's what has to be done. And while I'm on this topic of affirmative defenses, before we talk about specific affirmative defenses, I gave you one exception. Affirmative defenses are what the defendant has to prove, and in most states they have the burden of proving that. In New York, however, there is an exception. We're going to talk about it when we talk about self-defense, but the exception in New York is self-defense. It is the prosecution's burden to show beyond a reasonable doubt that there was no quote-unquote justification. When you're justified in acting, that is up to the prosecutor in New York State, but it differs from state to state with regards to that, so just keep that in mind. Perfect defense versus an imperfect defense. I touched on it a couple times, but I didn't give you this lingo, and now I'm going to do it. Perfect defense. What might you think a perfect defense is? When the defendant is full out successful and they get an acquittal. I was justified in defending myself. The jury believes it. You get a not guilty. Imperfect defense is when a defendant is successful in convincing the trier of fact that they should not be charged with that particular crime, but maybe a lesser crime. Maybe it's not murder one, but the jury or the trier of fact comes back and says, well, you didn't prove murder one, but it is murder two. So there would be two counts, not guilty on count one, but guilty on count two. That is considered an imperfect defense. Factual versus legal. And who decides? Well, a factual defense is based on some fact that exists or some specific ground. Alibi, for instance. Let's take that one. What's an alibi? That defendant was somewhere else at the time of the crime, so he couldn't have been that defendant, him or her. That's a factual. It's based on a specific fact in a case. And that is something for a trier of fact to determine. A legal defense is when the issue involves something of law, and that is for a judge to decide. And this could be something like the statute of limitations. That's the time frame for someone to be prosecuted for a crime. A misdemeanor, I think it's 3 years. Certain felonies are 6, and there's lots of felonies that don't have a statute of limitations, like murder. But if it's beyond a statute of limitations time, that's a legal defense. What else is a legal defense? There was an illegal search and seizure. That could be a legal defense. And these are things that a judge would have to determine. It's kind of as you might heard the lingo, he got off on a quote-unquote technicality. That's usually what they're referring to as some legal issue that was either done wrong or it didn't happen and it needed to happen. So factual defenses and legal defenses. We are going to be talking about factual defenses, and there are several different ones. Alibi, duress, entrapment, insanity, involuntary intoxication, excuse, self-defense. So we have a lot to cover, but let's talk about the difference between what justification is and what excuse is. In this instance, let's talk about Schmitty. Schmitty has purposely parked next to a fire hydrant near a hospital. When asked why he did so, he replies in one of these two ways. This is going to be our example. I had to. I was taking my injured baby to the hospital to save his life. Or, I had to. The Martians told me to do it. What do you think about that one? We're going to be either dealing with justification or we're going to be dealing with excuse. In these instances, the defendant is not denying that he or she committed the crime. Clearly, right here, see, he's not denying committing the crime. What is the defendant saying? With justification, it's going to focus on the offense or the act, and excuse is going to focus on the defendant himself. So let's take a peek at these two. The first one, I had to. I was taking my injured baby to the hospital to save his life. Would you put that in a justification category or an excuse? What does it sound like to you? Even just in common sense. We're focusing on the act itself. Should he be justified in parking his car next to a fire hydrant because he had to bring his baby into the hospital to save his life? Probably. That could be considered justification. We're going to talk about it a little bit more, but that's an example of justification, being justified in doing what you're doing. That's how it would be presented. Or I had to. The Martians told me to do it. It sounds like he's making an excuse, right? He's focusing on himself, the defendant or the actor. Martians made me do it. Let's talk a little bit more about justification. Justification. Defendant's conduct should be legal. This is the argument. Defendant's conduct should be legal because it supports the greater good. And as I indicated, this is kind of it focuses on the act that the defendant is doing, and it should be legal rather than criminal because it supports a principle that's valued by society. Okay? That's what justification is about. And self-defense is a form of justification. We're going to talk specifically about that. But let's talk about this. It is illegal to intentionally take someone else's vehicle without the owner's permission with intent to deprive the owner of the vehicle. It's grand larceny in the 4th degree. And then we have a law number 2. It is illegal to intentionally take and use someone else's vehicle without the owner's permission. And we're going to call that joyriding. Okay? It's a misdemeanor offense. So those are our 2 laws. Joe takes his neighbor Sandy's vehicle without her permission. He hotwires it. Sandy calls the police and says her car has been stolen. Here's the vehicle information. Police find the vehicle parked in the local hospital parking lot. Police conduct an investigation and they find Joe in the waiting area. He admits taking the car. He also tries to explain that he did it because his son stopped breathing and he needed to rush him to the hospital. And he had no other form of transportation, and Joe is arrested. Any arguments for Joe? This is kind of like the last example I gave you, except I kind of blew it up a little bit more. Is there anything here that could be argued? Think about it for a moment. It is illegal to intentionally take someone else's vehicle without the owner's permission with intent to deprive the owner of the vehicle. Do you have an argument there? This might be a failure of proof, right? How are you going to prove that he intended to deprive the owner? So maybe the prosecution can't prove this as it's written. How about law 2? It is illegal to intentionally take and use someone else's vehicle without the owner's permission. And that is a joyriding type statute, because the idea is that it would be returned. So maybe in this instance, this is a failure of proof. You get an imperfect defense. If the prosecution can't prove law 1, they could probably prove law 2. But then what might be a next argument? Justification. Could Joe be justified? Does it help society? Something, a principle that society would look the greater good, turn their head on? So these are the things, that's a possibility. So these are the things you got to think about when we're looking at a fact pattern and types of potential charges and types of defenses that are available. Let's cover excuse real quick, and then we'll go into the specific defenses. So excuse, like I said, focuses on the actor. Even though the actor did commit the offense, the actor should not still be held responsible for his behavior because the defendant's actions are excused, maybe because of some limitation or disability. So let's distinguish using the examples we just heard. Fight breaks out at a party and Toni is severely injured. Mike and Rob are arrested. Rob asserts, "I didn't touch Toni, someone else did it." Is there a defense? Yeah, I didn't do it. He might say, "I was someplace else at the time that happened, so it doesn't put me there." I don't give you that fact pattern, but that would be alibi, right? Mike says, "I was defending myself against Toni's attack." Is there a defense? Justification, probably. I was defending myself against Toni's attack. Who has to prove that? The defendant. The burden of proof by a preponderance of the evidence. Why would we allow justification happen in this case? Mike severely injures Toni, and Toni's like, I was defending myself against Toni. Because society believes that individuals should be able to protect themselves. And we're going to go into how far you can go with that. And I'm sure you probably are familiar or heard the term, quote unquote, stand your ground. There's been lots of public national cases involving that. Let's talk about one. Mike comes home and catches his wife in bed with another man. He shoots and kills them both. At trial, he argues insanity because he is so outraged and overcome with emotions that he lost mental control. And he has an expert who is a psychiatrist testify on his behalf that supports him. Do we have a defense? He's going to say he wasn't in the proper mental state. He was, at that particular moment, he became insane, overcome with emotion that made him act that way. Is that justification? No, this is focusing on the actor. This is an excuse. Although he killed and he had criminal intent to kill, if he was truly insane, the idea goes it's not fair to be punished for his behavior. So the question is going to be, but is this a flat-out acquittal, i.e. a perfect defense, or is this something less, i.e. an imperfect? Does this go from being murder 1 to being manslaughter? Do you think the person gets to walk out of the courtroom? Most of the time, no. And you're going to see that when we talk about insanity. There are some states that say if you are successful in an insanity defense, you will be acquitted. And there is one of the trials. The guy's name escapes me, but it's one of the trials that are in the trial list for the Criminal Trial Project. The man who attempted to assassinate Reagan. And that case in and of itself, if somebody chooses to do it, I'm going to give you guys little snapshots of the types of cases that are in there because they're great examples. That's why I have you pick one to write about. But it focused on the rules and the laws that changed the insanity defenses because of that particular case. So insanity is an excuse. It could be a perfect or an imperfect. Most of the time it's imperfect. And we'll talk more about why that is when we talk about insanity. Let's look at one more example. Instead, Mark goes up to his wife. He finds her in bed and all that jazz. Goes up to his wife and puts a gun to her head, hands her a knife and says, "Stab your friend until he's dead or I'll kill you and our children." And she does. And she's arrested for murder. Does she have a defense? Would you try and give her a justified? Remember, justification might get her completely out of it. It's not really self-defense, is it? Is it something else? Some sort of excuse? Focus on the actor. I'm trying to save my own life and kid's life so I could kill somebody else. She might argue something of an excuse of duress. She was under duress, but you will see when we talk about duress that this argument might not fly. So that's just kind of an overview of defenses, what categories they're going to fit in, whether it's justification or excuse, and then we'll cover some others.